Welcome everyone to the Quantum Marketplace event. We're going to cover Unraveling Legal for Quantum this time. Just a reminder on format, everyone is muted except the speakers. Please put your questions in the chat, and then a recording of this webinar will be posted in the future on YouTube. So in terms of agenda, I'll give a few snapshots, updates on the quantum marketplace, and then also some high-level overview and trends, unraveling legal for quantum. Then we're going to get into our lineup. We have 5 companies presenting today. Then we're going to get into an exciting roundtable discussion and then a snapshot of the upcoming schedule. So the quantum marketplace raises brand awareness, facilitates collaboration, deals, and partnerships. That's been our edict, and that's been the feedback that presenters have reported back after presenting. We have 2 aspects to the quantum marketplace. One is on the QED-C website, which is publicly facing. It has a directory of all the companies and a little pink icon there for the companies that have actually presented videos. If you click on a company name, you'll get a description of what they offer in the quantum marketplace. On the right side, there's a link and a website to a YouTube channel, which has all our recordings posted. We have topics ranging from quantum computing to quantum networking to quantum sensing, lasers, everything is there. Okay, some overview and trends. Again, this will be posted after it's recorded and edited and posted on YouTube. Today we have Quantinuum, YB, Zapata, Vescent, and Qunnect. And the four plus areas we're going to focus on today, because there's a lot of confusion that we keep hearing in the marketplace around legal challenges in terms of export control, intellectual property, the Committee on Foreign Investment in the United States, which is also known as CFIUS, and employment, and also, getting your company set up correctly. So, export control potentially, especially startups probably aren't used to this in the space, but it potentially impacts just about every company in the quantum space that's, working to look to do commerce outside of the United States, just selling product. It may be restricted, or you may have to get special permission to sell it. So we'll be touching on that today. And then intellectual property in the quantum sector has some unique challenges. It's not status quo. We're going to be digging into that as well. We're also going to be digging into CFIUS, and CFIUS doesn't come up all the time for companies, but it does come up from a high level, and, Kanaya is probably going to, dive pretty deep on this, but it comes up when you have an investor that is not based in the US, or an acquirer of your business not based in the US, or now even affecting some US-based investors that are looking to invest in foreign companies. And then employment, we hear a lot of workforce and the lack of talent in the ecosystem, and so that's actually, for some companies, they're looking at hiring non-residents. Well, that brings up a whole host of challenges depending on the quantum technology they're working on, especially quantum computing. And then also we're going to touch on, if your startup or company is looking to raise capital, or, if you're going to be acquired, you really need to keep your legal house in order. Many of the startups probably don't have that in order, so we're going to give you some guides on that as well. Okay, so with that, we'll get into the lineup here. We have Kanaya from Quantinuum. She's their Chief Legal Officer. We have Elliot at Young Basile Hanlon, and we've got Christopher Savoy and Johnny actually from Zapata Computing. We have Jim Pinto, who's in-house counsel at Vescent, and we have Noel Goddard, who's CEO of Qunnect.
So my name is Kanaya Kinkoli-Tege, and as Mark said, I'm the Chief Legal Officer for Quantinuum. Really quick, I would be remiss not to mention for myself and really every panelist here, what we're going to talk about today is not intended to be legal advice. It's really just intended to be general information. If you have specific questions about your company, I recommend you talk to outside counsel or your legal counsel. Okay, with that, as I mentioned, I work for Quantinuum. We are a full stack quantum computing company. We provide hardware, software, algorithm development, and cybersecurity solutions. And we have locations across the world between the US, UK, Europe, Germany, and Tokyo. Now, I wanted to just give that basic lay of the land because it really becomes important for us as a global company to talk through one of my favorite topics, which is export control. So if you're in the quantum computing industry, you will inevitably encounter a discussion around export control. And you might be thinking, why? I don't sell products, I'm not shipping things, why do I care? Well, I like to start with this quote from the National Security Advisor, Jake Sullivan, from September of this year. And he identified several technologies, including quantum computers, as being force multipliers throughout the tech ecosystem. And consequently, he said that it is critical for the US to maintain leadership in this ecosystem. And that was really a national security imperative. Very recently, the US has imposed some Russian sanctions, and he identified that those technology export controls are really important in serving as more than just a preventative tool. And most importantly, he said, if implemented in the right way, you have robust, durable, and comprehensive export controls. They can be a strategic asset in the United States and allies' toolkit for imposing costs on adversaries and even over time, degrading their capabilities. Why is this important? And why do you care? Because export control really impacts more than just the end product. So first, let me take a moment and talk through the three base regulators who provide support. You have Department of State. That's where you hear terms like ITAR. That really falls into military controls. You have Department of Commerce. That's the EAR. You have really dual controls there, commodities that can be used in both military applications or commercial, and then Department of Treasury, and they really regulate the destination, embargoes, et cetera. And as I mentioned, these regulations fall in either protection of the product, the destination, or who the end user is, or the end use. Now, an export is more than just a physical shipment of items. It also includes a release of technical data or potential software code to a foreign person. This becomes important because a foreign person is defined as anyone other than a US citizen or permanent resident alien, even if they are living in the United States. Now, I'll touch on this a little bit later when we talk about employment law, but I do think this is an important area to look at. Finally, the thing I wanted to touch on is for companies today, there's no unilateral controls on quantum computers as of the date of this recording, but there are certain restrictions that exist for controls around algorithms that the security is based off post-quantum cryptography. And as I mentioned earlier, the US and several other companies have imposed restrictions against certain Chinese entities and against Russia for very specific quantum computing controls. That includes computers, processing units, circuits, devices, control components, measurement devices, and cryogenic systems. So it's really, really important to stay up to date on what the US and other countries are doing as you continue to grow your business. The second area I wanted to mention is around CFIUS. As Mark mentioned, this comes into play as you start to do a fundraise. So what is CFIUS? It's the Committee on Foreign Investment in the United States, and it's made up of about 9 federal agencies that, again, this interagency committee, and they're authorized to review these transactions where there's a potential for a foreign entity, a foreign business, a foreign person to have control in the US. This process right now is voluntary. However, the process, the government can pull your transaction in, and the full process can take over 90 days. And that is really, really critical for startups who are really looking for cash infusion to think about, because it can be 3 to 4 months before you're ready to go through this process that you need to get your house in order. And then there's the outcome. So you can have the potential of clearing the transaction in total. You can clear with a potential mitigation, which means that you might get a national security agreement or some other type of agreement that may limit your ability to fully operate. Or in very rare occasions, you can have an actual prohibition against the transaction. So finally, and it's important to note on CFIUS that this includes mergers, acquisitions, joint ventures, leases. Again, as I mentioned, foreign person is defined very broadly and control is defined very broadly. So make sure you're paying attention to that. The other area we wanted to talk through is workforce and employment. Now, employment law impacts every business, from the proper hiring practices all the way through employment and to termination. So you really need to make sure you're tied out with your Labor and Employment Council in any of these areas. But what becomes a little bit more unique for quantum computing companies is around deemed export. As I mentioned under the export rules, a deemed export is when you basically share your technology with a foreign person, even if they're in the United States. This does not mean that you can just choose not to hire foreign nationals, as there's a number of discriminatory laws against that. So you really need to make sure you're checking with outside counsel and considering the type of position that you have, whether it needs to needs exposure to this type of information, and whether you can wall off the person while you're looking to get a license. With that, I will turn it over to the next speaker. Thank you.
Thanks. So yeah, I'm here to talk about my work at my law firm, Young Basile. We're a national IP law firm, and we happen to be a founding member of the QED-C. I'll start off with a few fun facts about our firm, and then I'll address what some of you may be wondering: why patents, why now? And I'll finish with a few tips to hopefully leave you something useful. First fun fact, our firm was founded the year I was born, 50 years ago. We have attorneys in various US locations. We specialize in patents and IP, but we also have litigation and corporate practices. Our corporate law offerings include employment law, startup law, mergers and acquisitions, in which we recently helped one of our startup clients go through the process of being acquired. And this link describes some of our offerings for startups. Another thing that many of our clients in the quantum space appreciate is that we can speak their language because of our backgrounds. In addition to our experience patenting quantum computing hardware and software, our own academic backgrounds include work in quantum communications, quantum sensing, and yes, that is my actual lab from my MIT days, and my lab mate tucked back there who went off to become an engineer at a large QED-C company. When we ask why patents are relevant now for the quantum computing industry, one thing that becomes clear is that the number of patents being granted in the US and around the world has been growing in the last few years, as shown in this chart from one of my recent talks on patent trends. But just because people are getting patents doesn't necessarily mean the industry is mature. So I want to answer the question some skeptics may ask: if most patents are never litigated or licensed, why are they relevant, especially when significant commercial activity and standards may be a decade or more away? I will first point out that a patent that has a 10-year lead on the field in an industry that will be mature in a decade is being filed today. There are also certainly true innovations, the crown jewels, that can be a primary reason to seek patent protection. There are also reasons to build a strategic portfolio, such as for due diligence that will occur in funding rounds or mergers and acquisitions. And thinking ahead for when standards do come, it could be useful to have patents that can be submitted as standard essential patents. Now, I'll mention a few tips for patenting emerging technologies. Provisional patent applications can be useful as a low-cost way to secure a filing date, especially when the technology is advancing at a fast pace and getting out into the world. But there are potential pitfalls that are important to avoid. Skimping on things like a full set of claims or thorough support for what's being claimed can risk the loss of the right to claim the benefit of that provisional at a future date. Another area where it's helpful to have a team like ours is when it comes to defining jargon and translating concepts into understandable descriptions. And when dealing with academics used to writing for publication, like those in our university and startup clients, where a lot of the founders come from academia, there's a key difference that should be understood between the academic world and the patent world, including differences in the ideas that make for good science and those that provide strategic protection. I'll end with a few tips for building a cost-efficient patent portfolio to make the most of a limited IP spending budget. It's important to use time in smart ways, both the time of the inventors and my time as patent counsel. It helps for us to talk to the engineers that are bringing products to market about their problems they're solving. And for the time they do spend writing up those ideas, a little training goes a long way. For example, one simple guideline of avoiding color in their diagrams can end up saving large amounts of time and budget later. As patent counsel, we want to make sure we understand your business goals to inform the guidance we provide. We can make sure the application is effective for each of the different audiences it may have, not just the patent examiner, but also investors, competitors, maybe even a judge and jury if the patent's ever litigated. And finally, I'll just say that there are a variety of other considerations that can have a big impact on how the overall IP budget is spent. I don't have time to go into it all, but we have a guide on our website with a variety of suggestions. Feel free to reach out if you want to explore possible ways our firm can help.
So just a little backgrounder initially on Zapata and who we are. Some of you know who we are already. We are a Harvard spinout almost 5 years ago now that is concentrated on software particularly. And so we have a little bit more color to add to some of the background that Elliot had given about intellectual property that can be very specific to software. And there are many hardware companies and hardware device companies and control companies involved in the QED-C, but oftentimes there are, even in those cases, software assets, software IP, and firmware particularly, or control software. And so we want to focus on those things as well from our perspective. So our purpose at Zapata is to solve the world's most computationally complex problems with quantum and other big compute, meaning TPUs, CPUs, GPUs, whatever it is, of course, including QPUs. But we have a perspective that it's a combination of all of those technologies to get all the different maths you need to get right in a solution, in a full solution. So that's what we do. And we have a product that integrates all of those things. A key part of this, since we are a software business, is our intellectual property portfolio on some of the key algorithms. And as Elliot mentioned, from our perspective, even if some of these things aren't going to run on a fault-tolerant computer for another 10 years, the patents are good for 20 years. So 10 years from now, you might be thinking back retrospectively and saying, why didn't I patent that? And that would be a very bad place to be if you've got competitors who did. So a second thing I'd like to point out, there are rumors and myths out there floating about that you can't patent an algorithm. Well, you can't patent math, but you can patent an algorithm, and there are ways to do it properly so that it's actually valid and enforceable and all of those things. So I'd like to kind of erase that myth that's out there for people, because that I think could be quite dangerous to companies, because as Elliot mentioned, this is how other companies look at a software company. One of the ways that they do diligence is to see, what is their intellectual property portfolio like? Copyrights, trade secrets, and then also patents, obviously. So you can see our patent portfolio here. It's pretty formidable. It's one of the top portfolios of gate model quantum algorithm patent families in the world, we believe. And it's up there when we're monitoring this with the likes of Google and IBM. So that gives you, if you're a software company, and you have a portfolio like this, permission to play at the table and things like Elliot mentioned. It helps you with trading horses when you have to, or patent pools and other things. It's not necessarily that you're going to sue people with it, but it does give you a nice defensive and position at the table. And then I'll turn it over, I think, to Johnny to think about some of the actual issues here, though, with the Patent Office when dealing with these software patent applications that we have.
Thanks, Christopher. Yeah, so in dealing with the Patent Office, one of the things you should be aware of is the fact that the Patent Office is limited in their technical expertise. And as you saw in Elliot's graph, right, with an increasing number of patents, right, the Patent Office is at this point sort of being overwhelmed with the ability to examine all of these patents in a meaningful way. And so, some of the dangers are the fact that the Patent Office may accept patents, very broad patents that shouldn't get through. On the other hand, right, they may lack the technical expertise to understand the novelty of something that is patentable. And another issue, right, is in the very interdisciplinary world of quantum, right? Sometimes categorizing these things is like putting a square peg in a round hole, right? So these are in particular the categorizations for the USPTO's quantum patents. And as you can see, you can imagine if you had a superconducting device that was especially good for, quantum error correction, right? Where would that go, right? And who would examine it? And so some of these things are really unclear. Thankfully, there is one program which the QED-C is helping to provide, and we have provided a little bit of training for at the Patent Office, called the Patent Examiner Technical Training Program. And essentially, this is just an opportunity for you to give technical talks to help train the staff. They will keep those videos. They actually share them, I think, with Canadian and Mexican patent offices as well. And so I highly recommend if you participate in this program or join the QED-C efforts to provide the patent office with some training. Thanks.
We appreciate the opportunity to present here. What's the next phase for your company? Is there a Series A financing round or a possible sale of your company in the near future or in your horizon? Is that 1 or 2 years out or 3 years out? And importantly, what can you do today? My name is Jim Pinto. I'm an intellectual property lawyer with 28 years of experience, and I work with Vescent Photonics. And I want to address those issues with you today briefly in the time we have together. By way of background, Vescent is a Colorado company located just outside of Denver with about 37 employees. Vescent designs and manufactures laser systems and laser solutions for quantum. Vescent produces environmentally rugged laser products that can be used and deployed by our customers in the field. Vescent's products include items such as optical frequency combs, lasers, photonic devices, and control electronics. Vescent's products support and enable the entire Quantum 2.0 ecosystem, including quantum computing devices, quantum networking devices, quantum sensing, and quantum timing. So in terms of your next phase, a typical transaction in terms of a round of investment, if it's your Series A or possible sale of your company, is first the negotiation of what's known as a letter of intent, or LOI, where the parties agree on the major deal terms and kind of the next steps and the rubric for the deal. That's followed up by an agreement and a diligence period, which can be 35, 45 or more days. And during the diligence period, the agreement is further revised and disclosures are made, and a definitive agreement is put in place, and then the deal closes. So there are certain things you can do now to prepare for that phase, because during the diligence period, the investor or the buyer is going to look into pretty much all aspects of your business, including the legal side. The buyer or investor is going to look into all of your corporate issues, your formation, your structure, your ownership, all contracts that your company has entered into, material contracts, important contracts that are the company has signed throughout the history of the company, your employees and HR issues, any kind of litigation or dispute related issues, real estate issues, including your leases or if you own real estate, your financials, including your accounts receivable, accounts payable, and then your intellectual property. They'll also look into other areas like your tax filings, environmental issues, things of that nature. They're really going to turn over every rock, particularly if it's the sale of your company. On the IP diligence front, and this is where I want to spend most of my time here in the remaining minute and a half, to talk about the things they look at in terms of IP. They'll look at your trademark portfolio, your patents, your trade secrets, the important ones, your software. Who owns your software? Who developed your software? Do you use open source software within your code, which most companies these days do? Do you have assignments from every person or entity that touched your intellectual property or contributed to your intellectual property, including contractors? Your non-disclosure agreements, your suppliers or vendors, whether you have tech licenses in or out of your company, your agreements with customers, if you've done any custom development for customers, if you've done any government contracts like SBIRs or others, if you developed any of the IP using university research or university resources. And then they'll also look at intellectual property infringement risks. So to prepare for that next phase, you can take steps now. Some suggestions on this front. First of all, be aware of every agreement your company signs. This may seem onerous, but you need to look at them and preferably have outside counsel or experienced lawyer look at the agreements, because they can include provisions in there that may not be favorable, that you may need to negotiate. Also, be cautious about disclosing your critical trade secrets without some form of non-disclosure agreement or confidentiality provision in place. If you have contractors or developers assisting with your IP development, make sure that they assign their intellectual property contributions back to your company so that your company controls that intellectual property. And then manage other legal risks like third-party patent infringement risks or other types of legal risks that will make the transaction smoother. If you have any other questions now or in the future, I'm certainly happy to help. Thank you so much.
I'm representing a startup company that has to hire a lot of lawyers in order to function in our day-to-day world. So again, my name is Noel Goddard. I'm from Qunnect, spoke at one of these earlier quantum marketplace events. Our company innovates devices to transform the existing telecom infrastructure into scalable quantum networks. And the device suite, as you see on the left there, is a set of devices which, because we've been through the IP process on this, like many of the talks which you heard here today, each one of them is a collection of patents that have to do with either features or the devices themselves. On the right-hand side, we're starting to build a test bed in New York, which again will end up more than likely producing more IP. And we know as we're starting to walk down this road that compared to the earlier days when the company was first starting, the best way you can deal with anything in intellectual property is to get out in front of it. So the moment that you have an idea, you should really be discussing with your intellectual property lawyers, and you should have intellectual property lawyers who understand quantum so that they can help you best strategically place your claims and your early filings into the patent offices. So something I really wanted to touch on is closer to what Kanaya spoke about at the beginning of the session today. And that's the fact that a lot of these things you think may not affect you, like export or CFIUS, because you're not doing this yet, can actually affect you, and you might already be violating things that you didn't realize you were violating. So for instance, I put a few examples here. When you start to craft an R&D business strategy, you're choosing to create a set of products. You may or may not be aware that some of those are already covered by the existing export control guidelines. And I put an example here. So this comes from some of the commerce classification language. This quote, designed or modified to use or perform quantum cryptography, is a very broad bucket. So my company does quantum communications. Is that the same as quantum cryptography? Well, you should know if you're going to be producing these types of instruments, because you want to be very careful that you understand the controls which are put in place. And again, there are experts in this at many of the full service law firms that have export control and CFIUS counsel. Similarly, the commerce classification rules are a living thing. So they can broaden over time. And what could actually happen is that something that is not controlled now could actually fall under some control language, even though it's meant to be under dual use. And a great example of that, which everyone was highlighting a few years ago, is a supplement that came out from those offices, actually controlling cryogenic refrigeration technologies. So again, it's something that you may not think of as naturally something that should be controlled, but it is something that falls under these laws, and you need to know about them in terms of your company's strategic direction. Similarly, if you are a young company, the chances that you're hiring people straight out of academia is high in the quantum space. And we all know that we have a very international workforce in the United States, which are getting degrees and doing postdocs here. And some of you may or may not be aware that when you start to accept different types of federal grant funding, all of those pages of contracts that you did not read when you were a graduate student actually come into play when you are now trying to build a workforce within your own company. And the reason for that goes back to what they were saying in the first talk today. Export is a broader defined term than simply exporting a device. It's exporting knowledge. So there are federal grants and contracts which actually have restrictive language about the persons which can participate in those grants. And some of those may be things that you take for granted, like an STTR from the Air Force. Well, read the fine print because it's important, but for the small business, how do you get around things like this? Well, the first thing you can do is you can create a technology control plan. Again, I advise that you work with counsel on this. And it actually allows you to isolate the project and the team members that are doing the project away from the larger group, which is at your company. And sometimes this causes you to actually have to rent a secondary space, but is something which is acceptable to some of those contracts. Secondly, you can actually work with an export control lawyer to classify the technology you're working on. And if it falls under a control category, there are exceptions called license exceptions for export, which you may qualify for so that you can actually work on these technologies with your international staff. Finally, something that some of you may be running into is that the foreign investors sometimes are a little bit more quantum friendly than the US investors. If that's the case, your foreign investors could actually trigger a CFIUS process, depending on the amount of their ownership. Or, as was mentioned also in the first talk today, there are other things that fall under the category of control, like having a board seat, which can also put you in the position of needing to actually file for CFIUS disclosures. Again, there are councils that specialize in this, but as we learned today, that's something which is like a 90-day plus process. So you just need to be aware of these things when you have a very small company. Qunnect, has been really actively pushing forward in the ecosystem since late 2019. And we've touched on every single one of the topics that you see here, as well as the intellectual property stuff that we heard about today. So with that, send it back to you, Mark.
So the great presentations. Thank you for that. Okay, so we're going to get into our roundtable discussion. I'm going to start off with Jim here. This is very open-ended. There's obviously a lot of things that we've just talked about that probably keep up a lot of people at night, or maybe they didn't know it. But Jim, what keeps you up at night, from a legal consideration standpoint?
It's where companies often don't either have the resource or the understanding that when they enter into some agreements, the other side may be using an agreement that can be one-sided with regard to intellectual property. And so the companies, wanting to do the deal or get the business or do the joint development, they enter those agreements without thorough consideration of what is the impact of the agreement going to have upon our company going forward. And that can really be tough because sometimes you have to unravel those or renegotiate those at a later time in order to make, if it's a big enough issue, in order to make the later transaction occur. So that's where I feel like it's very important to be aware of a lot of these issues, especially on the IP front, and frankly on all the topics touched on today for particularly an emerging technology company.
Well, I think that one of the things that we worry about constantly is the evolving landscape of commerce control. As a company, we've chosen a strategy because of having a large number of foreign researchers where we again were aware of where the line was for quantum encryption. And we very deliberately do not do quantum encryption at our company. That way we can still have an open workforce. But as those lines start to change, we have to be aware of it and try to constantly get in front of it so that we can continue to be doing the best research we can. The people who are actually drafting the regulations as best we can to make sure that these types of restrictions make sense.
Yeah, I think it is very much like you said. It's an all of the above answer for me. Check that box. All of this stuff matters a great deal. Few examples, anecdotes that might help. I mean, we had an Israeli investor in our voluntary CFIUS process that wasn't even required be questioned and made us go through a bunch of rounds of questions to get that done. We got it done. But we did need to use very qualified lawyers familiar with the CFIUS people and how they think and all of this to make that happen. So you might think that, well, a very friendly country in which, the US and has very friendly military relations with might be a no-brainer, not always. So that's one. The intellectual property stuff I've already explained is really, really critical even to software companies. So software companies or people working with software in and around their hardware should be very much aware of that. I think that's a thing. And the deemed export control thing that came up. There was a question, I think, in the chat just recently that, you know, what do you do if you have somebody who falls out of favor with these controls? Can you keep the person on? Well, yes, but they cannot work on those projects. That is illegal. It will get somebody thrown in jail in the worst case. I mean, that's how serious this stuff is. It is a felony to do that. So
yeah, right.
Yeah. So
right.
this is a big deal. You know, this is not just something you can play around with.
Well, the legal considerations that I worry about are making sure my client is well protected. The patenting process is actually very human, has a very human element to it. And so,
what do you mean by that?
Well, the patent examiners are the gatekeeper. And so even though, you know, I have a PhD in this, and so I might be at an advantage in talking about proclaiming some technical subject matter, especially quantum, but it's not necessarily a slam dunk if you understand the technology much better than the examiner. It's there's a lot of education that goes on, and so that they have the right context, and a lot of that will go up front. And the more you can be prepared in your patent application for who knows what kind of discussions you're going to need to have, oftentimes a year later, 2 years later. So when I get those initial filings, I'm very concerned about making sure my client has all their bases covered. Our claim strategy is robust enough that we can handle what's ever going to come down the line in a couple of years.
Kanaya. Thank you, Elliot.
Yeah, I mean, like Christopher said, all of the above. I think as a lawyer, you always worry most about what's the unknown. And so, of course, export control really stands out for me because we know it's a shifting landscape and we know there's going to be changes. And as Christopher and Noelle mentioned, the workforce is global. So making sure that you're really, really paying attention to what's happening, what countries are in favor, out of favor, whether you think you'll be able to get a license if you're hiring in a particular area. It's a very concerning space.
Great. So so what I'm hearing here is this probably requires, many of these areas that we're talking about require specialized lawyers or law firms. Would you agree, Kanaya?
Absolutely. It's really critical to make sure that you have a law firm that understands export control, that has and can understand some of the nuances of anti-discrimination in the United States. The Department of Justice in 2016 issued a letter that said, basically, you cannot discriminate just on a per se, meaning just because basis of someone being a foreign national and working on export control. So you've got to make sure you're working with someone who really understands these nuances. Yeah.
Noelle, I think you had mentioned you actually use multiple law firms, right?
So we have a different law firm.
I think the audience needs to hear that too, right? It's like it's not just a turnkey one law firm, maybe if they're really big, but what's been your experience with that?
So I think the company went through two important transitions. The first one happened because we started off with an IP law firm which had worked with the university on the original filings that were licensed into the company. While they certainly had lots of talent in order to qualify, normal types of hardware devices, they did not have anyone on staff that could truly read quantum patents. And I think that if you really want to work, if you intend on having a very strong IP portfolio, you need to actually be strategic about these things, as was mentioned by Chris and others. You actually have to get in front of it and be able to read what is out there in the landscape in order to draft the claims which are going to be meaningful. Otherwise, you're just wasting money and legal time. So one thing that was important to our company was to first change IP firms early on to find the right firm to work with and to use your dollars sensibly. The second thing that was important, I think, was to start working with a full service law firm, because as you mentioned, I have a lot of lawyers in a lot of different topics. We needed it because we breach over a lot of different things, and export control and CFIUS were some of them. So having experts within a full service firm is always a useful thing to be able to do that. And some of those actually also cross over into the IP transactional law space as well.
Okay, great, thank you. So there's a second part to this. Some of you are, focusing on different areas of this legal situation. So Jim, you presented on getting your house in order, and Kanaya, you talked about, wow, if you can't even do a CPS, application without having your house in order first. And so, Jim, I really want to ask you here, how important is this? I mean, what happens if you don't? Can you give an example of like what's happened when the house is not in order?
Well, sure. So I think it translates during the diligence period after the letter of intent is signed. The diligence period is
like if your company's going to be acquired, or
yes,
if an investor's going to put money in, and we've got a lot of startups in the quantum ecosystem, right?
Right. And so there's the diligence period. Let's say if it's 30 days, that's a lot of things the company has to work on, even if the legal house is in order. But if the legal house is not in order, then it's a lot of late nights by the CTO, the CEO, the outside legal counsel,
management is wiped out, right?
I mean, you're focused on getting everything, the documents in order, putting agreements in place if they haven't been put in place previously, getting the financials ready, doing all the stuff, and that takes away time from running the actual business. And so I think that's the biggest downside. Instead, if you take the approach that we're recommending today or suggesting, which is, mind these issues all the way through the life cycle of a company, you'll be in a better position when that LOI starts getting negotiated and the diligence period starts.
Yeah. Anybody else want to comment on this? I'd like to go to the next question.
Yeah, I'd just like to say, have a really good, well-constructed data room from the very beginning, from your seed round, from your A round, and keep those in place, and keep that historical data there as well, because you will be asked for it. And I'll say it in a positive way. If you do that really well, you can really accelerate the process and really actually positively impact your valuation, because you're seen as a mature company that knows what they're doing. So in an acquisition process, or even in a venture due diligence process, you will do it will behoove you to get that data room really nice, ordered, clean, with all the documents that you think that the other side would want to see.
Yeah, great. Thanks, Christopher. Okay, so, can software algorithms be patented? Christopher, you mentioned that they can. So, if yes, how and why should one do it? Because there is, as you said, there is some confusion and there is some discourse out there of, certain individuals are saying perhaps you cannot do it. So I think this is your sort of opportunity to expand on this. So have at it.
Sure. Yeah. Like I said, it's, there is this truism out there that's not really true. It's actually, sorry for the dad joke. It's patently false. But the problem is that people think you can't, there is this thing that you cannot patent math. That's true, right? You can't patent a piece of nature that is math, the, philosophy behind an algorithm or whatever, the actual concept. But what you can do is say, I'm going to implement this on a computer. That is a process. That is an actual patent. Maybe I'll turn it over to Johnny for a little bit of color on this, because he's looked at it pretty extensively.
Thanks. Yeah, there is, maybe to give a little background on this question, right? So there was a decision, often people refer to it as Alice, which really restricted the ability to patent methods on computers. And, although maybe the decision, at the time was right, it seems that the patent office sort of went overboard in applying this principle. And so it is, it has been maybe historically somewhat difficult to get software patents, and hence maybe where this myth came from. But in that decision, the patent office laid out exactly how you can still get one of these patents, right? And it's essentially by connecting it to some technology. But one of the difficult considerations in quantum is that the language of quantum computing and other quantum technologies is inherently mathematical. So even though you might be describing something which is very concrete, like a Hamiltonian, right, which is describing your system, the examiners often read it as, oh, this is a mathematical object. And so it can be really difficult, right, to get examiners to interpret something as being, a concrete quantum invention and not merely math. And so you have to be very careful sort of about laying those definitions down in the patent and trying to, ensure that the examiner can't merely just broadly apply whatever definitions he finds on Wikipedia or something.
Yeah, right. Elliot, do you get into this area when you're IP practice?
This is a great example of one of those areas that, again, has that human element. I mean, so there's the Alice decision. That was a Supreme Court decision. There was regulations and a memo and various things that flow from that are guidance from the Patent Office for how examiners should apply the law. But that's not necessarily consistent from examiner to examiner. So often it comes down to any one person you're talking to, whether it's this patentability issue, which isn't just for software, it's for abstract things that are considered abstract. You want to be ready for that conversation you're going to have with that person. Who knows what they're going to need to get over the line, and so you want to be ready to have those definitions, as Johnny said, and have things in your application that you can point to and frame it in a very practical implementation of something. The more you can make it practical, very concrete steps or structure, the easier it will be to get away from this notion that it's just an abstract idea.
Yeah, great. Kanaya, Jim, Noel, you want to comment on this? No?
I was actually thinking that it mimicked a little bit some of the decisions that were made some time ago when there were concerns about not being able to patent genetic sequences. And they have to be tied in, in the pharma community to the end use, which in itself can be patented. So again, tying to the technology end use.
Yeah, great. Okay, so wanted to show this. This is courtesy of Zapata, and let Christopher and Johnny start off here. But as I was reviewing this with Johnny before the event, and on the left you see these software patents, and on the right you see these are all quantum computing companies, or I guess, and look at the right, and you start seeing, again, I'm gonna let you guys expand on this, but why is Bank of America, so far out there? That's kind of wild, right? Johnny, you want to comment on that, or Christopher?
Yeah, I mean, one thing to note, I think, first is just the methodology of this slide. So so this data was taken by so that the right panel is just eliminating all hardware companies from the left, essentially, right? Of course, the left could go higher, but and so what's interesting, right, is how few both patents we see on the quantum software patent portfolio side. So in other words, right, there are a lot of hardware patents, right, and correspondingly very few software related ones. So that's maybe because of this issue that we were discussing just a moment ago, right? In some sense, the difficulty of patenting software, and also, the fact that hardware companies are, sort of itching to have any advantage over their other hardware opponents. But I was shocked, I suppose, a little bit to see how much the banks are involved. on the right-hand side. And I can color it a little bit and say that the banks seem to be very interested in use cases. So most of these patents are very specific, I assume related to their, to their business issues. But the frequency is what is surprising, right? And many of these have been, so not only are these patent portfolios somewhat old, but they're increasingly, the frequency with which they're patenting is increasing as well. And so it's interesting to see that the financial institutions may be sort of the first competitive regime in this quantum patent world.
I guess what's also interesting and striking to me is that if you look there are many quantum software companies out there who are members of the QED-C and other organizations around the world, right? And we're kind of feeling lonely on that right side of the bar there. And maybe that's part of the messaging, that people think that they can't get a software patent, and that maybe we can be useful in curing that notion a little bit today. And maybe because they think it's not valuable or whatever. But if you look on the left side, clearly Google and Microsoft and IBM are doing it. So it's probably not a stupid idea to be thinking very seriously about the value of those software quantum patents.
Right, and correct me if I'm wrong, but in my experience, it's really important to have patents, because it's not about excluding someone else from being able to do something. It's so that you have a right to practice. So if someone claims you're infringing, or you want to expand on that?
Absolutely, it's freedom to operate, and particularly for we hear a lot about patent trolls, these little companies that are causing a lack of innovation. You hear a lot of that from the big companies who pay a lot of money to try to weaken the patent system in Washington, because little guys, they just want to be able to sell their software and exist. And a patent can actually help you do that, because guess what? If they misuse your patent, you can sue them. And they know that, so they try not to.
Right.
There's freedom to operate, that, to your point, is very important and very critical. It's like I said in my little talk there, it earns you the right to be at the same table as even the big guys.
Yeah. Elliot, I don't know if you've ever seen this slide from the team at Zapata, but any thoughts on it?
No, it's a very interesting slide. I'll just comment also, just so people are clear. In some sense, there's no such thing as a software patent. All patents are, the same rules are applied to every patent. And a lot of the patents I filed will have that, like for a software company that I represented for a while, a lot of the claims we had in there covered, methods and the apparatus, and so you'll have hardware and software in the same patent often. And so for companies that see their techniques being used as software or hardware or both, there's room for flexibility in that in any given application. And they should take advantage of all kinds of claims for whatever ideas they have.
Yeah, Elliot, when we chatted before, you mentioned, and I also heard the same thing from Christopher and Johnny in the past, but I think sort of want to wrap up the patent conversation here, but a lot of bad patents are getting issued right now. And what does that do, Elliot?
Well, bad patents, some people might think, well, maybe it's not something to worry about, because if they're bad, they won't hold up. But there's a presumption of validity that you have if you get a patent past the patent office. It can be very expensive to, even if that patent should not have been granted, it can still be formidable and expensive to deal with. And so some companies could use that to their advantage and try and get the broadest claims they can. But it could also be, it's a double-edged sword. So it is a big issue, patent quality.
Yeah, right. Noelle, you want to add on this, or we go and move on?
I would just like to I would like to add one thing, and I would really encourage those companies, particularly if you don't have an in-house counsel, to maybe take a little bit of time, particularly for the founders, sit down with patent counsel and take a moment to kind of learn a little bit around the law, so that you can, because if you really need to understand some of these nuances to set a strong patent strategy, right? So as you're looking at your technology, whether it's partnering, you know, if you're a software company and you're looking to partner with a hardware company, or you're looking to do end use cases, and you want to understand whether or not it makes sense to have shared IP or anything else, or you even want to understand freedom to practice, freedom to operate, where there may be a what some practitioners may call a white space, meaning that there's kind of an open area for new technology that you could look for opportunities to patent. Just take a little bit of time and learn some of the basics, because that's really going to help inform your strategy. And, you know, it is expensive to patent. So you really want to make sure that you are taking a really smart approach to how you're going to build out your portfolio. But it is absolutely critical. And I do agree with what Christopher and others have said. I really do want to see, you know, more companies pursuing good, strong patents in this industry.
Yeah. Great. Thank you. Okay, I'm going to go right back to you, Kanaya. You seem to be the resident expert here on export control. What are the best practices? So, you know, how do you approach it? If you're a small company or a company that really doesn't have this kind of in-house expertise like you have, what do you do?
Great question. So first things first, I would say get familiar with your technology and get familiar with the Commerce Control List. So if you're a hardware company, as Noel mentioned, and even in some nuances on post-quantum encryption technology, but I would start with the Commerce Control List. I would look at the various categories and start to familiarize yourself, because what you're going to need to do is understand the way in which you're going to categorize a particular either subcomponent part, unless and until the full quantum computer system is controlled. Let's say you take the section on lasers and optics. You want to understand what actual subcomponent parts that you might have in your system, and then you want to understand how they're controlled, if they're controlled. And then you want to understand what countries would require a license, because some require a license and some don't. Again, it's a really complicated area, but I would really encourage people to just, again, take a little bit of time, see if you can even Google Export Control 101, listen to some of the QED-C various events on this topic that kind of help provide that backdrop, and then really just take some time and walk through the Commerce Control List and realize kind of what that structure and framework looks like.
Thank you, Kanaya. Noel.
I was just busy answering one of the questions in the Q&A box. It was a little on the more complex side, but
it's starting to light up. Yes, yeah, Johnny's very active.
But you know, so for Qunnect, the interesting part of our story is that we actually engaged export control at the very beginning, because we were concerned about being able to transition a very international scientist base, which we need, because we're very proud of the core team at Qunnect, but doing something which always was treading on the edge of national security. And I think that the best thing that we ever did sort of strategically was to say, okay, let's engage export counsel up front, understand where the boundaries are, just as Kanaya was saying, understand what the legislation says, talk to the people, if it's their practice. So whenever you talk to a specialist in export control law, very often they're reading all of the stuff which is in the more emerging parts of the literature, and they understand what's coming down the pipe at some point, which helps you as a company start to develop a better strategy. But it's worth every penny to make sure that you're in compliance, because you don't want to be on the wrong side of this, as we were saying earlier, in terms of hiring or anything else, because you are actually breaking laws. And I think, you know, strategically speaking, I mean, in terms of our product development and goals that we had in R&D and other things, it's very different than when you are at a university. And that's something that I really need to stress for people who are coming out of universities and going into companies. When you are working in the academic research only space, although there may be some restrictions on what happens on university grants, it is a completely different ballgame when you are a private company and those restrictions apply to you, again, being compliant with, you know, actual export control law. So for instance, we also use our export control lawyers to add, you know, the documentation into our normal employment agreements. because we need to have sort of a rider in the back so that we understand that people will not violate, export control laws, et cetera, on grants where they aren't allowed to be working on them, et cetera. But those are the types of things you don't think about whenever you're a young company, and then all of a sudden you're sort of thrust into it. So.
Great, thank you. Christopher, Johnny, you want to, or Elliot or Jim, you want to touch this topic?
On best practices, well, I think one of the best practices is, I think Qunnect already mentioned, is getting with your counsel and understanding this stuff. I think that's really important. I think overall, if I could give some advice, is that you're going to need some good attorneys. I think this has been touched on a little bit. Maybe it's several firms to get the portfolio of what you need. You might need lawyers. If you have an all-you-can-eat kind of place, that's great. Like Noel has had some success with a full-service firm. But oftentimes, those big firms will be conflicted if you're a small company. And also, they may not have the boutique expertise in exactly the area that you want. CFIUS in a particular jurisdiction, or patents in a particular jurisdiction or area. I mean, one of the reasons Johnny is now a trained and up-and-coming lawyer soon in this area is we were conflicted out of a lot of law firms that had the expertise for quantum. They couldn't do work for us, even if they wanted to. So this is a big issue.
Wow.
So,
Wow.
Yeah, that was a big motivation for us. We're like, well, how are we going to do it? We can't get a law firm to represent us. Hey, Johnny, what do you think about this? And we had a conversation, and there you go. No, seriously, I think that this is also a bit of a workforce development issue in our community, is that there aren't a lot of quantum knowledgeable lawyers to go around. So I would encourage any of the small and even big companies as a best practice to start shopping for your lawyers pretty soon. When you get that A-round funding, start thinking about who's representing you in commercial transactions and everything, because you may end up talking to 5 law firms before you get one lawyer who can actually represent you. So that's a big deal. I would say start that early, and you may have to have also in-house counsel in an area like this, where it's very complex and there are so many legal issues that touch upon it. You may need, I think, in this case, if you're a quantum startup, an in-house lawyer a lot sooner than you might want to, or that your VCs might think you need in the cycle, because you can get things wrong, and some bells are impossible to unring.
Yeah, right. Thanks for that. Okay, Noel, this is going to be right at you. Starting with you, many companies face challenges hiring qualified talent with, specific quantum expertise. So, what are you doing when you're hiring and when you're looking at the pool of non-residents? And how does your business operate? And what happens when you hire these people with your workflow?
Right. So it's something that we've always found very challenging. So this includes even Qunnect's founders. So we very early on needed to start dealing with the fact that basically everyone who worked for the company in a technical capacity was a foreign citizen. Some of those entities are better or worse than others because they fall into different lists. So for those of you on the call, there are sanctioned countries, which actually fall into a different category when it comes to being able to get some of those.
You mean like a T list, right?
Correct. So sort of 2 different types of foreign citizens under these types of rulings. So unfortunately, there are countries of concern, and those of you who have Department of Energy grants may have recently noted that you have to sign more forms now for the Department of Energy, declaring which foreign persons will be working on the technologies which they are funding you to work on, and they specifically list out the countries of concern. It's just where we are in the world today. At Qunnect, philosophically, we've been very determined to try to have open hiring practices. We want to hire the best people to do the work. This comes with compromises, which is why we started to learn very early on about export control, and to try to understand where the barriers are so that we could still hire the best people, but to have the right people doing the right projects. So sometimes strategically, you have to just be aware of the fact that, for instance, we accepted a United States Air Force grant early on. It required us to rent a second space. And this is something that you see.
Because why?
Because there was a restriction on foreign participation. And Those restrictions can be handled through renting a second space. They also can be handled through writing a technology control plan, which I highly advise would be, again, seen over by a lawyer, so you know what you're doing, so that you're in compliance with the contracts that you're trying to fulfill. The other thing is oftentimes the data has to be isolated. So if you have cloud storage, for instance, that you're sharing across your team, you have to have a completely separate set of this for contracts which have those restrictions. Where this gets a little bit more complicated is as a company grows, if you would like to do business with the US government on some very sensitive topics, like quantum encryption or something like this, the restrictions are actually strong enough that you need to actually form a US entity that has an all US citizen board in order to do some types of contracts with the government. It is a pathway which is known in the world of export controls, so it's understood how this all works. But you as an entity, if you plan on doing business with the defense side of the government, should be aware that these things exist. It allows you in some ways to be able to continue to do basic research within your company that has foreign researchers, but then do business with the government under an entity that looks like it is an all US entity. So Qunnect is again, educating ourselves about these pathways because we know we probably are walking down these paths sooner than later. But I encourage all other startup companies who are within this that, it is time well spent to go out and have conversations with people who are experts within export control and CFIUS, because both are very complicated and both are changing landscapes.
Yeah, great. Kanaya, you want to add on this?
Yeah, I think Noelle did a great job of kind of covering the basics. One thing I want to emphasize, and Noelle touched on this, is the criticality of doing an analysis as to whether or not you can wall off the individual. Because as I mentioned earlier, it's not enough just to say, oh.
So that's like IT, that's like another building. What does that look like?
Yes, all of the above. And it really, so first you need to understand what the role is, what it requires to do its job, right? What information it may need. You need to understand where your current data exists, right? So let's say you have a SharePoint that everybody's been using, which, by the way, you should even think about that, because depending on what platform you're using to host your data, it may not actually reside in the United States. So you always want to be really careful about kind of the entire infrastructure that you're building out as you build out your company. But yes, to your point, Mark, if you have an individual, you need to understand that is a foreign national coming in and working on this information. You need to understand, one, whether it is a matter of getting a license, meaning that maybe they sit on your roles and they do some basic work, but you have to wait the period of time to get a license, or they may not ever get a license and you may still need to employ them if they can perform their work without having access to the data that would be necessary. It's very complicated, but and it does involve physical and logical walls of separation. So again, highly recommend you talk to outside counsel.
Right, or you also, Noelle and Kanaya, you try to work to get the person a green card, right? So you've done that.
I'm only laughing because I'm saying that is a slow process. So I can tell you
it's just painful. It's very painful, right?
Well, you have no control over the actual feedback time. So Qunnect has a number of employees who are foreign scientists who recently received green cards, so we're thrilled. But all of them in different staggered times that didn't seem to follow any sort of rationale that correlated with when they submitted their paperwork, what countries they were from, who were allies or not to the United States. None of this made any sense. So when the green cards started coming through, what it gains you, which is relevant to this conversation, is that for purposes of export, you are now considered a US person when you have the permanent residence or green card, which then opens up some of these barriers that were formerly the restrictions on the grants that I mentioned earlier.
But they still can't join your board, right? Even though they're a founder.
Depends on the country. So,
right.
when Kanaya was just talking about the license, so every single technology, so if the technology is actually controlled under export codes, there is a very complicated chart, which again, somebody needs to interpret for you, They can tell you what type of license exception can qualify. And you can apply for that as a way to have someone from a country which is not sanctioned participate in said project. For companies which are on the sort of critical list, again, as sanctioned countries, there's no path to have a license exception.
Okay, great. Thank you for that. Christopher, you must face some of this too, right?
We do. We absolutely do. We're global. Where we hire people where they are, because that's what you have to do when you're trying to find quantum talent nowadays. And I would say that, you know, immigration law is a big piece of some of what you need to do. So that's another piece of outside counsel you want to get good representation with, who really know how to do it. Because, you know, just your local law firm that does visa applications is not going to work here. You may be going pretty high up in the food chain to get these things done and get them done expediently. Yeah, you have to be really careful. I mean, there are a whole bunch of little nuantical things that people don't think about, like, oh, well, I'm dealing with a Canadian national, not a problem, right? Yeah, but they're a dual national with a country that's on the list. So you are committing a felony by giving that person certain information or devices or whatever. So you need to be careful with that. But then employment law gets in the way here. What are you allowed in Canada to ask your Canadian employees upon employment about their nationality status? See, so you know, it's really hard to thread the needle sometimes with these things. So, you know, there's no panacea, there's no answer. And sometimes you have to take sometimes a bit of risk assumption in these things, because there's no, you're wrong on this side and you're wrong on that side. So what do you do? So you have to take the path of least risk and least liability, probably. And again, talk to your own lawyers. I'm not your lawyer. So as Kanai said at the beginning, I guess the thing is, get really good legal advice on this stuff with people who've worked the problem before. And don't go to counsel and say, yeah, I'm just a general employment person, if they haven't done international stuff and they haven't done actually deemed export control specifically. Learn that word, deemed export control, and ask that question.
Yeah. Elliot and Jim, do you want to add to anything that was said already?
Well, I'll just comment that Christopher was explaining about, you know, different firms. I mean, I used to work at one of these big law firms, and there were a lot of conflicts. So it can.
And Elliot, what's a con? I don't think the audience may know what is a legal conflict at a law firm. Well,
that can be a murky issue sometimes, but a lot of times a firm will just, you know, say they can't represent certain companies. If they already represent a big player in a space, then competitors of that company may have a difficult time getting services of that.
You get like a waiver or something like that, right? Or not, right?
Yeah, that you can do that in certain situations, but generally it can be difficult. So yeah, it's actually easier now at the firm I'm at now, as opposed to one of the big law firms. We're sort of a medium-sized firm, and it's actually much easier for me to represent startup companies at this firm than it was when I was at that huge firm.
Oh, yeah, great.
And we also, I mean, to solve the problem of you can't just go down the hall and have an expert in X, Y, or Z, but what we tend to do is partner with firms, and it kind of frees us up to get the best person that really knows that area. We can partner with boutique firms that know their stuff in a particular area. And so that's how we tend to serve our clients in these broad areas, is by we know our lane and we help them, we think, well,
stay in your lane, yeah. Right.
In our lane. And then if they require help, we try and get them the real experts for those other lanes.
Right. Jim?
I just want to echo what the panelists have said, that, yeah, these export control, ITAR, government contracting issues, highly specialized, highly complex. You know, get yourself lawyers, outside counsel that are really effective with this. And I will say on the conflicts issue, hopefully for some of those larger law firms, you might be able to convince them to represent you in a limited capacity, for instance, regarding export control issues or compliance, as opposed to just general business representation, because then in that way, or IP representation, where there can be business conflicts. If it's just your company trying to be educated and compliant with export controls, ITAR, and government contracting issues, hopefully the law firms can draw a line there and say, okay, we can represent multiple players in the quantum space with respect to these export control, ITAR, and government contracting issues.
Yeah, great. Thank you, Jim. Okay, so I want to go back to, this is probably the last question. We're out of time here, but Kanaya, so you talked about the CFIUS approval process, it takes some time. What does it look like? And also you mentioned, and I wanted to highlight for the audience here, if they're going to be going through a situation like this, you have to have your legal house in order first. So sort of like what Jim was talking about, can you sort of give a whole picture of what this looks like? Like I'm a company with 20 people, and and I've got someone wants to acquire a company, and they're outside the United States. What does that look like in terms of a timeline, or an investor? What does that look like typically?
Great question. So, and before we even get to the CFIUS piece, I would say the house in order piece should not be, don't discount it. So just to be really clear for folks who are listening, if you don't quite know what the term due diligence means, think of it like this. You have a bunch of lawyers, potentially accountants or other financial experts, right? Third-party auditors. You have technical experts who are going to come in and do a top to bottom review of your entire company. And so when you hear people talk about the due diligence, right, or that you're going to be putting into your data room all of this information so that these potential investors can go through and look at it. That takes time. It's going to take time on your end. It's going to take time on their end. Why do I say that's even before CFIUS? Well, because you need to understand who your investors are. So let's assume you're moving super quick. You already have everything in place. Maybe that's taken a month or two, maybe, which is really, really aggressive, I think, in some cases. But let's just say that's taken time. Once you go through CFIUS, and again, it gets a little bit complicated because it may be a voluntary disclosure. It depends on kind of whether they're investing a certain percentage. I think it's 25% or more of your overarching investment for the business, whether you have governance rights, whether they get a seat on the board, et cetera. So there's a few triggers that come into play. But so you write out your application, and you do need to be explaining some of the things around what your information is, who's going to have access to it, whether or not there's governance rights. All of this stuff goes into the application that goes before CFIUS. They have some time to accept it. So maybe a few days. Then they start a review process, and that takes 45 days. Given the nature of quantum computing, right, the government needs to go and look at all of the various experts to talk through national security. And just to be clear, CFIUS is based off of national security, not necessarily economic security. And so it may take some time for them to continue this process. So depending on what your structure looks like, you may very well go into what's called a second 45-day investigation time throughout all of this process. Okay, so now we're talking just a solid 90 days from the moment the government accepts it to the moment they come out with something, a decision. But there's a lot of questions that get asked. And I think Christopher mentioned you can get asked questions that are not unlike what you may get in diligence. But the reason I say all of this is, let's just say you get through this 90-day period and you get a decision and you have to come and live with it now. You're talking about a process that could take anywhere from 4 to 6 months. And I think especially for new startups, it's really important for founders and leaders to recognize that you've got cash burn happening during all of this time. And so it's, once you've kind of locked yourself into what you want the next investment round to look like, right? You have this cash burn, and you still have potentially up to 6 months of managing this process. And then you also have to be mindful that there may be additional restrictions that come on you as a result of this. So you really need to be thinking about, similar to what Noel was talking about, the government may come in and ask you to have particular walls up, not allow certain, groups to have certain types of information. There may be
Right.
audits that the government has. And so all of this infrastructure now starts to come into play.
Yeah. Now, I know we're going a little long here, but this is really, really important. We've been sort of the discourse here has been from the position of the companies presenting, and what you need to sort of be mindful of when you go through these particular processes. But and Noel, and I want you to sort of maybe talk with Kanai about this, but the investor actually has to deal with, if you're a foreign investor, so we're talking from a company perspective, right? But the foreign investor has to go through it too, right? It's not, so you've had investors, Noel, that you said that have been through it before, so that sort of streamlined it, but others said, I don't want to do it, right? So now you're a CEO, Christopher's a CEO, you guys are running around, you're raising money, you're doing whatever, and you have a foreign investor, maybe a European investor, and they want to put money in, but whoa, they don't want to pump the brakes. They don't want to go through CPS, right?
Well, certainly the board seat is the one which is I think always a sticking point, because sometimes you have developed a relationship with an investor you really want on your board. And if it's a foreign entity, then that is a CFIUS situation. So yes, we've been through requesting a foreign investor to sit on our board who did not want to take his fund through this process. And then the other side is just the pure numbers that Kanaya was talking about earlier. I mean, you need to be aware when you start putting together these deals, what you can actually accept in terms of total amounts.
Right.
And a lot of times it's even a board observer thing. If you read the language in the guidance, it's just having influence on management, which is very broad. And if they want to say no, there's plenty of air for them to say no on that. So even things like a board observer seat can be an issue, and access to management, whatever that means, right? So I would seek guidance on that. And really, what you need to understand, though, is the consequences are of letting $1 from one person that's not been approved into there could ruin it for everyone else. The worst consequence in this is that you would have to give all the money back. So you'd run out of money. The company would be broke. So people really have to realize that those are the stakes here. So yeah, I want to.
There's no way. There's no way to accelerate it, right? There's no way to go fast, right?
Well, there is, but it's on the company side and the investor side, really. You're not going to change, just like an SEC process, you're not going to change the question and answer time on their side, right? But there are prescribed times, like Kanai mentioned, like 45 days, they will give you an answer. It may not be the answer you want. We're going to the next stage, but you will get an answer. So it's a little bit better than some of the other regulatory things I've dealt with in the past in that way, because there are some prescribed timeframes. However, your ability to get your investors to provide information that they may not want to or may not have access to. They're a publicly traded company and they need to have access to who their shareholders are. They may not know. They may have to go find that information, or they might have to tell you who their LPs are. And they might not want to tell the US government who their LPs are, or anyone for that matter. So those are the kind of things you're going to have to negotiate to accelerate the process, are your ability to get the answer back to the CFIUS board, your ability to get your investors to get you the information. That's where you can control things.
I think you're touching on something like important there as well. And that's the fact that as a small company, when you start to think about who you're going to accept money from, you shouldn't be afraid to ask where the LPs are for those firms, particularly if there's not a long history of a portfolio or something like this, because there are initiatives from some of the countries of concern to establish funds into different companies within the United States from a U.S. entity in order to gain information rights, which puts you also in violation of many of these export things we're talking about today. And we certainly went through that process. So Qunnect just raised our first priced round. We were approached by a number of firms, which unfortunately had LP bases that excluded them from us being able to accept money.
Yeah, great. Thank you. Well, I got to move on here. Elliot, I do want to make one comment. You have a patent blog, right?
Yeah.
Want to comment on that?
Yeah, so some of you may have seen, I gave a talk about sort of updates since I put out one on patent activity in quantum computing, another one on patent activity in quantum communications, and soon I hope there'll be a follow-up to those based on that talk I gave. But yeah, I'll just sort of echo what my chart showed, and it's true of communications as well. It's a declared trend. China is a big player on the global scene. They have a lot of numbers in both those areas. One other comment I'll make is that, we can throw up these numbers of, oh, here are, all the patents on quantum or quantum communication. It's very hard to actually find them sometimes. Even in my own, I know in my data, it's kind of an art, not a science. To the way I do it is rather the classification codes at the USPTO are not very helpful. So I just do my own keyword searches based on what's in the claims, see if it's truly claiming something in that space. So that's another variable that whenever you see charts like these, that's another thing to keep in mind of, how are they classifying, how are they finding these? But hopefully.
You want to drop your blog in the chat if people want to see it, the link?
You can find it from the QED-C website. Let me see if I can find it quickly and drop it in. But
great.
If I don't manage to do it, it's there. Yeah.
Yeah. So in terms of upcoming quantum marketplaces, we just finished Unraveling Legal for Quantum. And the next one's actually going to be live in person at Quantum West, Photonics West in San Francisco. We've got 7 presenters. It's going to be very exciting. It's going to be Solutions for Deployed Quantum 2.0. Also want to do a little plug here. The QED-C is going to start a new series, potentially quarterly, on Quantum Business 101. And, sort of one of the topics could be, for example, really diving in the whole session on export control. And Chris Bishop has graciously accepted to lead that charge. So you'll be seeing that as well in the future. Celia, you want to finish with any words?
No, just thanks to all the panelists today. It's been a fantastic presentation, and I had lots of questions. So I think it's a topic that's going to be ongoing. And of course, many of the folks who are part of this panel are also part of the quantum law TAC. And for people who want to really, actively engage, you might consider getting involved with that TAC if you're in the quantum law space. So thanks to all the attendees and the panelists.